started? I want to thank you for joining us for this important event about an even much more important statute. My name is Ted Ruger. I'm a professor and deputy dean here at Penn Law, and I'm pleased to introduce this panel and then have four of my esteemed colleagues, all of whom are experts in civil rights and anti-discrimination law and the Civil Rights Act, will share each in turn their four perspectives on this important statute. I want to also thank Dory Pavel and her staff here for organizing the event at the law school, and Ralph DeLucia from the Central University for helping publicize it broadly, and it's great to see such a good turnout. So we're here to celebrate an important birthday, if you will, for the Civil Rights Act, but I actually want to introduce this by talking about three birthdays. The first, of course, is the 50th birthday of the Civil Rights Act. Now, I'm well aware that as we stand here in January of 2015, celebrating the 50th anniversary of the Civil Rights Act of 1964, although we're lawyers, not math majors, it's not quite aligned there. But here, to that, I'll just say, as somebody who has a 6-year-old daughter who celebrated and was proud to proclaim her 6-and-a-half-year-old birthday recently, we're pretty much at the 50th and a half birthday of the Civil Rights Act. It was signed in early July of 1964, so I think we can get away with it that way. There's another important 50th birthday coming up of another equally important statute that was part of the same legislative initiative in the Civil Rights era in the mid-60s. This is the Voting Rights Act of 1965. It's fitting that here we have the faculty panel about the 64 Act, so late that we're actually into 2015. One of our student groups, the Black Law Students Association, is having a panel just next week in January of 2015 on the 50th anniversary of the Voting Rights Act. That's the Sadie Alexander Conference, Saturday, January 24th. You can find information on the website. So it's a good place to continue this discussion and continue with a series of events we've had at Penn to celebrate and examine these crucial pieces of legislation a half century later. But I want to introduce the panel by talking about a third birthday, and also appropriately that at this time of year, that's the birthday of Martin Luther King Jr., who of course was instrumental in the struggle that we'll be talking about today. Now, the national holiday this year falls on Monday the 19th. Dr. King's actual birthday is January 15th, tomorrow. He would be 86 if he were with us. And he was instrumental in this struggle, and now, of course, some of those efforts of his are memorialized in a major movie about the March in Selma and related events that were very much interacting with what was going on in Washington that we'll talk about today. King's speeches from that era are part of our American vernacular when we talk about civil rights and the fight for equality. And I want to use his words to introduce the panel, but actually not his words from this civil rights era when he was a national figure. He was a precocious communicator even at a much younger age. And some of you may know he wrote an award-winning essay as a high school student at age 15 in 1943 called The Negro and the Constitution. And his words there speak to, I think, what's very important in thinking about this statute, and both historically and in its application today, namely the inadequacy of the constitutional guarantees in the 13th, 14th, and 15th amendments in fully realizing or operationalizing the normative values that they sought to embody. So King, at age 15, here writing in 1943, said, "America gave its full pledge of freedom 75 years ago. After tumult and war, the nation in 1865 took a new stand, freedom for all people. The new order was backed by amendments to the National Constitution, making it the fundamental law that thenceforth there should be no discrimination anywhere in the land of the free on account of race, color, or previous condition of servitude." Today, however, King wrote in 1943, "Black America still wears chains. Today, 13 million black sons and daughters of our forefathers continue the fight for translation of the 13th, 14th, and 15th Amendments from writing on the printed page to an actuality." So those words were powerful then, they're powerful now, and I think I want to focus on this notion of translation that we embody in very ambiguous and inchoate fashion in our founding documents, principles of equality and access to justice and voting rights. But the words of the Constitution don't do anything by themselves, they don't interpret themselves, and they need other institutions and people to fully translate them, as Dr. King said. So what we're going to talk about today was one major effort at that translation. But of course that translation itself, the '64 Civil Rights Act, is itself merely words on the page, more words, but more pages, but it's equally a potentially dead statutory letter without institutions and people to give meaning and life to those words. So I think this notion of translation is important, and I think this statute was one effort, an incomplete, unfinished, and ambiguous effort to translate in the way that Dr. King was talking about the original amendments after the Civil War into some more meaningful protection for equality. So that's what we're going to be talking about today, and I have four very distinguished and knowledgeable colleagues who are going to do that in order: Wendell Pritchett, who's our dean, Serena Mayeri, Sophia Lee, and Tobias Wolff, all on the faculty here. If I gave you their full eminent CVs, it would take up our whole time. I'll just kind of aggregate some. Each one has authored or co-authored a book, in some cases multiple books, about some aspect of civil rights and anti-discrimination law. Three of the four have PhDs in history. Two of us, I should say, I'm with Tobias Wolff and being a mere JD, which is increasingly rare in today's law schools. Collectively, they've written dozens of award-winning articles, and not merely confined to within the walls of academia. All of them have participated and had successes in operationalizing these anti-discrimination values out there in the courts and cities and real world. The only way they're not kind of representing a diverse and eclectic group of experts is all four have JDs from Yale Law School. So we're very happy that they saw the light and came here to Penn, and very lucky to have them here. So in turn, Wendell, Serena, Sophia, and Tobias will share their thoughts with you. So, thank you.
Thanks, Ted. Good evening. It's a pleasure to have all of you here. I do want to thank Deputy Dean Ruger for two things. One, because he really was the mastermind of this effort, and I really do appreciate your thinking this through and organizing it. And secondly, personally, I want to thank you for serving as the moderator so I can pretend to be a scholar for an hour instead of being an administrator, which is what I usually am. Let's go. The passage of the Civil Rights Act was a watershed moment in American history in several ways. And I just want to list a few. It was a watershed moment in the history of America's long and ongoing struggle to produce equality of opportunity for all our citizens. You know that. It was a watershed moment for the civil rights movement itself, a movement that had been organized not exclusively, but in large part specifically to secure the legal prohibition of the formal and informal structures that prevented persons of color from full societal participation to do what the Civil Rights Act attempted to do. And so that was certainly an important thing, a moment for the civil rights movement. It was an unexpected watershed moment in the nation's long struggle for gender equality, as I'm sure we will talk about. And it was a watershed moment, in my view, for a more expansive view of the role of the federal government in American society, a trend that began certainly with the New Deal, or possibly even a little bit before, but escalated significantly with the passage of the Civil Rights Law and was followed, as you know, by several other laws that really did change our relationship with our federal government, and we still continue to debate today. So the immense attention paid to the Civil Rights Act of 1964 in the judicial system, in our legislative process, and in our public debates over the past 50 years is more than justified. The Civil Rights Act helped create a new framework for the thinking about our relationship to each other and the relationship between the government and the people. And it is appropriate that we gather this evening to acknowledge the Act's impact, discuss a few of the myriad historical and current aspects of the law, and to engage in a discussion about our continued obligations toward each other's to fulfill its meanings, to fulfill the meanings of the law. I'm going to talk briefly just about the general contours of the Act and how it passed, and then talk about one aspect that I've done some research on. The Civil Rights Act of 1964, that I will frequently refer to just as the CRA to save time, banned discrimination on account of race, color, religion, sex, or national origin. The law applied in numerous aspects of public life, but it focused in particular on public accommodations, government programs, and employment. Introduced in the summer of 1963, the bill that became the CRA was hotly debated during the congressional session. The prospects for the bill's passage fluctuated wildly during the year, and most pundits forecast that advocates would not secure the bill's passage. There was a lot of negativity surrounding this bill for reasons that were understandable. Momentum for the bill began to increase after the wildly successful March on Washington, which we also celebrate its 50th anniversary only a few months ago, and it accelerated, as you know, after the tragic events of November 22nd, 1963. The Civil Rights Bill was one of the Johnson administration's main priorities, and in a speech just days after Kennedy's assassination, Johnson really placed it on the country and argued that there was no better way to eulogize the fallen president than to pass strong civil rights legislation. This really was a turning point, I think, with regard to the act, but only one of several. Though the core of the bill remained intact, the bill's advocates made many compromises during the process, most significantly narrowing its scope to regulate the private economy less than originally proposed. Again, something that we've continued to debate, the role of the bill and others in regulating the private economy as opposed to government action, which I think we're fairly clear on, though there are many debates about them too. Many unsung heroes played important roles in the bill's passage. I just want to mention one, somebody who's gotten a little of attention in the last year because two books have mentioned him, a guy named William McCulloch. McCulloch was a Republican representative from Ohio. He also happened to be the ranking member on the House Judiciary Committee, which was in Democratic hands at the time. He was among the most important people to securing Republican support necessary to counterbalance the opposition of Southern Democrats. As you know, at the time, most of the South was Democratic, and most of the Democratic congressmen and senators did not agree with civil rights, almost all of them. A longtime supporter of civil rights, McCulloch was the person who actually directed the floor vote on the bill, which was odd, again, considering that he was a Republican and the House was controlled by Democrats, which passed the House by a vote of 290 to 130. An impressive margin, especially given the negative predictions many journalists made of the bill's prospects. So the bill was taken directly from the House of Representatives to the full Senate. I'm going to just briefly mention this. It's interesting, particularly for us historians. Usually that bill would have gone to the Judiciary Committee and the Senate, and as if you've read much of the history, you know that the head of the Judiciary Committee for the Senate was a senator named Eastland, who was adamantly opposed to pretty much all civil rights legislation. And so the administration, working with the Senate, made a conscious decision to take the bill to the whole floor, which resulted in 57 days of debate, the longest debate in the history of that body. 57 days the Senate spent debating the Civil Rights Act of 1964. As Professor Lee will, I'm sure, discuss, the bill brought together an amazing diversity of activists and advocates, from religious organizations to labor groups to community institutions, that together formed what I think was probably, most people would argue, was really the first modern grassroots legislative effort, certainly of the capacity and intention that this group acted. I mean, certainly there was other lobbying before, but I think it really did establish the kind of modern approach to grassroots lobbying. So yet another watershed moment. And after many twists and turns, the bill passed the Senate by a vote of 73 to 27. So, it's important to understand the numerous areas the bill did not cover. Meaningful protections for the right to vote had to wait for another year, as Professor Ruger just mentioned. Though advocates attempted to use the bill to promote residential integration and prevent housing discrimination, those provisions had to wait until 1968 for the passage of the Fair Housing Act, and I'm going to come back to that in just a second. The CRA did, however, achieve significant progress in removing legal and structural barriers that excluded blacks and others from engaging in commercial activity, participating in educational programming, and taking advantage more fully of public facilities around the country. The bill banned discrimination in employment and created the Equal Opportunity Employment Commission, one of the examples that Professor Ruger alluded to of an institution whose purpose was to protect the interests of workers, particularly workers of color and female workers, and an institution that in years to come has played a major role in promoting economic justice in this country. So before I turn the podium over to my colleagues, for the next couple of minutes, what I want to do is examine the efforts to ban housing discrimination in this period, an area that I've spent some time looking at. I want to do this because it's an important topic in and of itself, at least I believe it is, but also because this effort both highlights how momentous a step forward the Civil Rights Act of '64 was for our political system. At the same time, I think it reveals how much more work was needed, was to be done. So I want to do both of those things and just tell you a couple of vignettes about the fair housing movement in the same period. So during the 1960 presidential campaign, Senator John F. Kennedy frequently, at least when talking to liberal audiences, criticized the Eisenhower administration for failing to act more aggressively for civil rights. This was one of his campaign platforms, at least again, when talking to liberal audiences. Highest among his criticisms was the failure of the administration to bar the Federal Housing Administration from supporting racially segregated residential developments. Blacks and other people of color had been almost completely excluded from the post-war suburban housing boom, which changed the face of this country, and much of which was backed, as you probably know, by federal guarantees. Our suburban housing boom was built by the federal government. Noting that the government was actually promoting segregation, and that such a policy change did not require congressional assent, because, you know, it was in the 1950s fairly hard to get meaningful civil rights legislation through the Senate. Kennedy stated frequently in speeches that banning federally supported segregation could be done, quote, with the stroke of a pen. And he actually even used pens as props to talk about what President Eisenhower and therefore Vice President and presidential candidate Richard Nixon should have been doing. However, after the election, things changed. So President Kennedy appointed fair housing leader Robert Weaver to run the Housing and Home Finance Agency under which the FHA, the Federal Housing Administration, fell. So this was obviously a heartening to civil rights activists, because Weaver had been a civil rights activist for his whole career, and activists took it as a sign of Kennedy's commitment to civil rights. However, for the next 2 years, Kennedy, fearful of congressional backlash on other administration agenda items, again, remember he had said, well, this doesn't go through Congress, delayed issuing the executive order banning federal housing discrimination. It took a campaign during which the White House received over 10,000 pens from activists to achieve the signing of a very limited order directing that FHA offices attempt to convince developers to allow racial integration. That's what they said. Would you please, developers, allow racial integration, as opposed to actually banning discrimination, so fairly different. So that was in 1962, understand. So that just 2 years later, a presidential administration could champion a sweeping civil rights bill and push it through Congress is testament to the hard work of civil rights activists in that period in changing public opinion about the importance of legal equality. I think it's very difficult to acknowledge or understand the dramatic change that occurred in our nation's, at least many of our people in our nation's thinking in that very short period of time. And I think it's important that we dwell on that for lots of reasons that I might come back to. At the same time, it's important for me to note that the CRA, sweeping as it was, again, was limited in its impact in the area of housing discrimination. So I'm not going to go into the area in detail. It's fairly complicated, and I'm happy to take questions about it. It's fairly complicated and a little boring. But in essence, there were questions whether the act applied to the Federal Housing Administration, which, despite its name, was actually considered a quasi-governmental organization, even though it was called the Federal Housing Administration. So it was unclear whether the Civil Rights Act of 1964 actually applied to the FHA. And big surprise, most of the leaders of the FHA decided that it didn't. The agency continued to support racially segregated communities and provide them with federal subsidies until 1968, when the Fair Housing Act specifically banned such activities. And as you know, while we have made meaningful progress in residential integration over the last decades, we continue to be a society of racially divided communities. And that path certainly wasn't started in the 1950s, but it certainly was entrenched in this period. So it certainly does help us understand some of the limitations. So my colleagues will address several interesting historical aspects of the CRA and also discuss the ways it and our understanding of civil rights has evolved over the past half-century. From my perspective, the CRA, while it certainly did not usher in an era of full equality, that fight continues, its success lies in its direct attack on government-sponsored discrimination and discrimination at the workplace, so that was a meaningful change, as well, I think, as its impact in changing the terms of the debate, in making equality under the law the default, under which governmental and some private activity should be judged. Today, one of our debates centers on the question of color blindness versus color recognition. I expect that we'll be talking about that a little bit more. You know, the question of should the law ban all consideration of race, or should it take into account, as I believe, I'll still lay my cards on the table, that past racial discrimination that continues to limit opportunity, and therefore it must be acknowledged specifically in policy. The Civil Rights Act, and one interesting tidbit is that the Civil Rights Act, despite its many pages, actually never defines discrimination. It never is there's no definition of discrimination in the Act, which was a conscious decision. So of course it doesn't really help us answer the question that I proposed, right? How do we solve this question about two ways, of course, among many, to look at what we mean by anti-discrimination? And so it doesn't help us answer this question. Now, before I end, I said, I think that debate is relevant, and I expect that we'll have a little conversation. I do want to also lay my cards on the table that I'm not sure how important the color blindness versus color recognition debate is. If you think about all the different challenges we have today, there are a bunch of questions that framework doesn't really resolve, wherever you stand on that one. But what I want to say before I wrap up my remarks is I want to acknowledge that the debate we're having today between color blindness and color recognition, that debate is a very different frame than that which structured our discussions before 1964, again pointing out, I think, the impact of the Civil Rights Act. Problematic as the idea of color blindness is, in my view, today, that posture marks for many the conservative end of our race discussion, right? And that's a great advance over the days not long ago when respectable people argued that lynching was okay. Lynching was not illegal, right? So let's understand the changes that we have experienced. So it's appropriate that we mark the 50th anniversary of the Civil Rights Act, and it's also appropriate that we discuss the next steps in the struggle for equality. And I look forward to engaging in that conversation with all of you this evening. Thank you.
I'm actually going to break ranks and stand because I sometimes talk with my hands and I don't want to elbow anybody in the face verbally. So I also want to thank Ted for coming up with the idea of this panel and for including me on it. And I'm going to actually in many ways pick up on Ted's theme of translation. I thought that was a really nice way to open the panel and fits very well with what I'm going to be talking about. This process, how do you translate principles into lived reality? And the first thing to know is it requires a lot of work. It requires a lot of creativity. And as Ted mentioned, it also has to be manifest in institutions that can make that reality sustain itself across time. And I should just say this work often is not particularly flashy. It doesn't necessarily involve big speeches or great, just great court wins. A lot of it is technical work. A lot of it is somewhat, tedious work. It's a lot of repetition and just pushing incrementally, pushing your agenda forward. So I'm going to be talking in some ways about that part of it, the sort of the more grueling aspects of translation and the different institutions through which lawyers and civil rights advocates try to make that translation occur. Here you are. You are a civil rights advocate. You spent 20 years fighting for this Civil Rights Act. It's finally enacted after these, marathon debates in the Senate, this, nail-biting question of whether the law would actually ever be enacted. And lo and behold, July 1st, 1964, the law is made real. What do you do now? You pack up your bags, go home, and say, "Whew, wow, we accomplished that, our work is done," right? No, that is just the beginning of the work of making what you've now got printed on a piece of paper, a very important piece of paper, but still just printed on a piece of paper into an actual lived reality. So that's what I'm going to be talking about. What did these lawyers and advocates do on the next morning, the morning after they celebrated, and then what did they do when they didn't pack up and go home? And I'm going to focus primarily on Title VII. That's the title of the Civil Rights Act that barred employment discrimination, and speaks mostly about race discrimination because Professor Mayeri is going to be talking more about sex discrimination. And I'm going to bring in a little bit about Title VI as well. That was the title that barred discrimination in federally funded programs. And that is an often underappreciated but extremely important part of the Civil Rights Act. So I will also touch briefly on Title VI. So how did they do it? Right? How did these lawyers and advocates wake up the next morning and decide, this is what we're going to do to try to make this law real? One of the first and most essential things they did was mobilize at the grassroots, okay? And why did they do this? Well, it's great to have a law barring employment discrimination, but particularly in the South, where what had happened was there was such a long-standing tradition of certain jobs just not being available to African Americans, right? The only way you were going to challenge that form of discrimination is if you could convince people who for years had no reason to think it was worth their time to apply for a particular job to go out and apply for that job. So one of the first things they did was mobilize at the grassroots. And this is just an example, a quote from Floyd Harris, who was himself a civil rights activist. He didn't need anyone to mobilize him. He already was mobilized. And he was one of the first African Americans to apply for and actually get a job in a textile mill in West Point, Georgia. And for anyone who doesn't know, the textile industry was one of the most racially exclusive industries in the South, and that's saying something in this period. So Mr. Harris said, look, I knew if the federal government made it a law, it'd have to be followed. And that faith, that because the law now said it would have to be followed, it was worth going and applying for this job that for decades had been off limits to him. It was that kind of courage and faith that really created both some new job opportunities, but also some new challenges that you could bring under the law to try to actually translate its promise into reality. And I should say, some of these workers went on their own initiative. They were, like Mr. Harris, already mobilized, but also organizations like the NAACP and the NAACP's Legal Defense Fund sent community organizers out into communities in particular states to encourage workers to go and apply for those jobs they never thought they'd have a chance of getting. When some of them, unlike Mr. Harris, were denied the job, what did they do? They turned around and they made complaints to the EEOC and filed suits in federal court, often with the help of the NAACP and the LDF. What did this moves to the next stage of translation, right? Because what did this do? Why did they want so many people out there filing complaints and bringing suits? They flooded the EEOC, the agency that was implementing Title VII of the Civil Rights Act, with complaints. They flooded the courts with complaints. And just to give you a sense of this volume, in the first months that the EEOC was open for business, the agency was receiving over 200 complaints a week. Okay? This is a new agency, just opened the doors. Already, these folks have gone and applied for a job, been denied, and have their complaints ready to go, 200 a week. In the first year, the agency received, I've seen different numbers, but I'll say conservative figure, about 9,000 complaints in the first year of opening its doors alone. By the end of that year, it already had a backlog of over 3,000 complaints. Right? So it got way more complaints than it could possibly handle. And in fact, by 1972, the backlog at the EEOC of these complaints had grown to 54,000 complaints that the agency, this isn't just how many were coming in, this was how many had come in that the agency hadn't even had time to deal with yet. Okay? Another number to give you a sense of just what a flood of litigation and advocacy these workers and their lawyers put forth after the law went into effect. Over 1,200 class action lawsuits were filed between 1965 and 1971. This was a tremendous amount of legal effort to do this, and a tremendous amount of workers who were willing to sign on. So why did they do this? Why didn't they just pick one or two perfect test cases to prove the legal point? Why did they flood the courts and the agencies with these complaints? Well, one was they really wanted to demonstrate the scope of the problem. They didn't want anybody thinking this was a small problem, or this was just a few outlier employers, a few bad apples out there, right? So one purpose this served was demonstrating the scope of the problem that the law faced. Okay? The second purpose of flooding the courts and the agency was to build a case that the existing enforcement mechanisms were woefully inadequate, that the problem swamped what Congress had created to deal with the problem. Okay? And here their concerns were first that the EEOC, while it was incredibly creative, its initial staff, in trying to do the most with the little bit that it was given by Congress, the EEOC was a small, underfunded, understaffed agency. That's why it already had 1 out of 3 of its complaints in its backlog within its first year of business, and that backlog just continued to skyrocket over the following years. They also were very concerned that court litigation was very lengthy and very expensive, and that the reward to these brave workers who went and applied for these jobs would be far too long in coming, with a law that was only going to be enforced through this kind of individual or class action litigation. So flooding the courts was not just about litigating each of these workers' claims and flooding the agency. It was also about making a political point. And those activists and advocates then turned around to Congress and persistently pushed it to amend the law to strengthen the enforcement mechanisms. And while they certainly did not get all that they wanted in that regard, Congress did in 1972 finally give the EEOC the ability to bring cases in court. Before that, all the EEOC could do is try to mediate a resolution between the parties. And if that failed, you were on your own going to court, hopefully with a lawyer, if not all by yourself. And so Congress did in 1972 finally give the EEOC the ability to go to court itself and try to at least pick some of those really key strategic test cases to push the law in a stronger direction. But so far I think most of what I've talked about is what you think lawyers do, right? They lobby Congress, they bring court cases, right? This is most of what we might expect lawyers to do in the wake of a law like this. But legislating and litigating was not the end of their strategy. And I'm here just going to take a brief detour to tell you about a man named William Taylor. And I tell it partly for the law students out there to have a sort of a possible career path if you translated something that happened in the middle of the 20th century into the beginning of the 21st century. But William Taylor, after law school, went to work for the NAACP Legal Defense Fund. This was in the early 50s. He worked there in 1954 and onward, not on the very famous education litigation LDF was involved in at the time, but on employment discrimination litigation the NAACP was doing. So he started out at LDF. He moved from there through into the Kennedy administration in the 1960s. He worked on the campaign and then joined the administration and eventually worked his way up in the Kennedy administration to become staff director of the Civil Rights Commission, the United States Civil Rights Commission, which during this period was doing a lot of sort of watchdog, big public hearings, trying to put public pressure on the government, so the government being a watchdog to the government about doing more on civil rights. So he did that through the Kennedy and Johnson administrations, and then in 1968, I think seeing the writing on the wall about where the 68 election was headed, he decided to leave the Civil Rights Commission, took a sort of a breather year at Yale Law School as a fellow, and while he was there, he used his time to write research and write a report for the Leadership Conference on Civil Rights. Now, what's the Leadership Conference on Civil Rights? This gets back to what Dean Pritchett was saying I might talk about, the vast array of people who were involved in getting the law passed, right? The Leadership Conference on Civil Rights was a key part of what held all of those various parts of the movement together. It was sort of an umbrella group that brought together labor organizations, religious organizations, civil rights advocates, all together in one kind of strategizing hub. And they've been working together since the 1940s to try to get this legislation passed. So they too, once the Civil Rights Act was finally passed, the LCCR did not disband, right? It just went to work trying to figure out how to translate this new law into action. And so William Taylor wrote a report for the Leadership Conference on Civil Rights, and this report was titled Executive Implementation of Federal Civil Rights Laws. And this report wasn't just about Title VII, what I've been focusing on, but all aspects of the Civil Rights Act. And he was really dissecting how was the government doing at translating this law into action. And while the report was largely about finding where the gaps were, and there were many places in which the translation had not yet occurred, he also had a note of sort of a prod or a note of caution for the LCCR itself. And what he said is, and I'm just reading from his report here, in some measure, failures to achieve greater gains under civil rights laws are attributable to the failure of private civil rights organizations to devote resources to monitoring executive performance at all comparable to those that they've employed in legislative lobbying, and I might add litigation. Right? He said, you guys are missing an important piece of the puzzle just going out there and lobbying Congress and bringing cases in court. You've got to get on top of the bureaucracy itself. You have to get on top of the government institutions, the offices whose job it is to translate this law into action, not just by maybe hauling them into court in a suit, but much more proactively, trying to push them to adopt the kinds of policies you want. And the Leadership Conference took Taylor's advice to heart and worked with Taylor, and together they organized to improve the picture of executive implementation that Taylor's report had depicted. And they created, one piece of this was they created a federal regulatory task force within the Leadership Conference within this task force brought an array of different kinds of activists together to think about how strategically can we go about sort of holding the feet of government agencies to the fire on this array of issues. And here I'm just going to give you some examples of the things that they did. So one thing the task force did was monitor and lobby agencies that were charged with ensuring Title VI compliance. Again, this is the part of the law that banned discrimination in federal programs receiving programs receiving federal dollars. Many of these were actually not. They were often state and local programs. And as my example will show, one thing they did was push the Treasury Department in the 1970s to cut funds to the Chicago Police Department unless it corrected what one news report called its flagrant employment discrimination. So they said, look, we know this is drastic, but you can't just threaten and control them. You have to cut off the purse strings. You have to say you're going to lose your federal funding unless you do something to have a more diverse police force in the city of Chicago. Another thing they did was petition agencies for regulations that would implement the civil rights laws. And again, building on the same example, they also pressured the Treasury Department to adopt guidelines going forward that would clarify for all city police departments and city government what is required for recipients to meet the statute's prohibitions against discrimination. They also urged the agency to require local governments to convene sort of citizen watchdog groups that would monitor local compliance with Title VI. So again, trying to mobilize a grassroots level group that would aid in this in monitoring this very distended relationship between these agencies in Washington D.C. and all these different government bodies around the country that were using federal dollars. Another thing that these lawyers did was they went to work for the agencies themselves. And once they're pushed for strong interpretations of these laws and enforcement of the law. An example here is another LDF lawyer, Derek Bell, who many of you may have heard of before, who this is early in his career, he'd been at LDF, he then went to work for the Office of Civil Rights in the Department of Health, Education, and Welfare in the late 1960s. Now this was the office that was tasked with using Title VI to pressure Southern schools to desegregate. Okay, so he'd seen the court litigation to try to desegregate schools under the Constitution. Now he was able to use those purse strings to try to pressure districts to make changes. And in fact, in 1966, the Department of Health, Education, and Welfare deferred or canceled funding, federal funds, to 20% of Southern school districts. So they, just like the Chicago PD, they said, we're yanking your money unless you make changes, and then they actually did that. And by 1972, though it's hardly perfect, but a recent history book that focuses on the successes of the Civil Rights Act says, and this is by an economic historian, so I'm trusting his numbers, much better than mine, that the South had the most racially mixed public schools in the nation by 1972 as a result of the efforts of Hugh and of lawyers like Derek Bell in its Office of Civil Rights. On the back end, these lawyers also then brought, after the civil rights advocates went into government, they brought them, when they left government, they brought them back into these regulatory monitoring efforts, because now these lawyers had particularly useful expertise in how the government worked and could make those kinds of regulatory monitoring efforts much more successful. Okay, so that was just a brief overview, but I wanted you to get a sense of how much work and creativity was involved in trying to ensure that that this law on paper, the Civil Rights Act, was actually translated in practice into changes in everyday people's lives. It's certainly, the monitoring efforts I'm talking about here are not the only reasons that this occurred, but they're part of the reason why, by the end of the 1970s, Title VII, which honestly, I mean, as much as it was a triumph that it was passed, it also, to advocates at the time, seemed riddled with weaknesses and compromises. Nonetheless, by the end of the 1970s, it had really surprised pretty much everybody who had backed it and yet been disappointed by it with its strength. And it's also why I think today, when we gather for these kinds of celebrations, it is important to celebrate the tremendous achievements of the Civil Rights Act, even as we recognize the limits and work on improving the law and on bringing more victims of discrimination within its protection. And I would just, I guess, end on the note that any changes to the law that may be forthcoming, this is also just a reminder that if they're achieved, and I'm thinking here of adding things like sexual orientation and gender identity discrimination to Title VII, or Title VI, if that's achieved, that's really just going to be the beginning, just as it was just the beginning when the Civil Rights Act itself was passed. There's going to be a huge amount of work from there forward in terms of translating that into real changes in real people's lives.
So I too am going to stand. And I too want to thank the organizers for including me in this distinguished panel. I'm really honored to be a part of it. I'm going to focus today on sex and gender equality, paying particular attention to some of the themes that have already been raised in the panel, namely the diverse array of actors, social movements, advocacy organizations, plaintiffs, lawyers, legislators, judges, administrators, who play a role in creating legal change and sometimes obstructing legal change. I'm going to start with a historical perspective on this so-called sex amendment to Title VII of the Civil Rights Act. Then I'll give a few examples of how the interpretation of Title VII's sex amendment has evolved over the past half century. And finally, I'll try to provide a tentative assessment of where we are today. So I need not remind anyone here that the civil rights movements of the mid-20th century were hugely important in winning the passage of the Civil Rights Act of 1964, as we've just been discussing. One thing that the story of sex discrimination and Title VII, I think, highlights in particular is that social movements and legal change also have had a reciprocal influence on one another. And in particular, the passage of Title VII, the employment discrimination provision of the Civil Rights Act, had a uniting and a galvanizing effect on the women's movement. So at this time, in the early 1960s, advocates for women had been divided for decades over a number of things, but two issues in particular. One was the wisdom of enacting an Equal Rights Amendment. The ERA was first introduced in the early 1920s, and I'll say more about that in a moment. And the second thing that they were divided about was the proper relationship between racial justice and sex equality. So one of the issues that was most divisive among advocates for women was the issue of sex-specific protective labor legislation, which was threatened by advocates thought by the enactment of an Equal Rights Amendment. So as you may know, during a period in which the U.S. Supreme Court was hostile to protective labor laws for men, things like minimum wage and maximum hours regulations, on constitutional grounds, advocates for women argued that women's role as mothers justified these kinds of laws, minimum wages, maximum hours, sometimes weightlifting restrictions, for women only. They had a constitutional barrier to arguing that they were appropriate for women and men, so they focused on women for that reason. The passage of a law prohibiting employment discrimination on the basis of sex helped feminists to overcome those internal divisions. Second, I mentioned that there was a debate about the relationship between racial justice and sex equality. Some white feminists had really, for a long time, but particularly in the 50s and 60s, when various pieces of civil rights legislation were before Congress, and the Equal Rights Amendment was also before Congress, some white feminists had allied with racial segregationists to seek protections in the name of white women in particular. And Title VII, by addressing race and sex discrimination together and tying together the fates of the racial justice and women's rights movements, ended that alliance once and for all. So I want to say a little bit more about that. There's a widely believed myth about Title VII's sex amendment, which is that its passage was basically a joke or a fluke, essentially a tactical error by segregationists who were trying to derail the civil rights bill. There's some truth to the idea that segregationists were trying to derail the civil rights bill. But I think more importantly, feminists and many female members of Congress actively lobbied for the inclusion of this provision. Unfortunately, some of them did so by appealing to fears that, again, that white women would be left out in the cold if only African Americans were protected. And this leads to sort of a second myth about the Title VII sex amendment that persisted even after it was recognized that it was not completely a fluke or a joke. Now, historians now credit Polly Murray, an African-American civil rights activist and feminist strategist, with persuading lawmakers to retain the sex discrimination amendment on the grounds that without it, as she put it, 1/2 of the Negro race would be left unprotected. Okay. So apart from its uniting effect on the women's movement, perhaps the most galvanizing impact of the early laws against sex discrimination was the very fact that they were really not enforced in the early years. The lawmakers who passed the Civil Rights Act and many of the officials charged with enforcing it, certainly not all, but many, didn't initially take sex discrimination very seriously. And their failure to enforce the sex discrimination prohibition in the early years of Title VII led more or less directly to the founding of organizations such as the National Organization for Women in 1966, whose primary goal upon its founding was to realize the promise of equal employment opportunity for women. Polly Murray, the civil rights activist and feminist who was largely responsible for the inclusion of a sex discrimination prohibition in Title VII, threatened a women's march on Washington in 1965 if the newly formed EEOC continued to drag its feet. So in other words, it was only when, and this continues a theme that Professor Lee just talked about, it was only when feminists within the government, in public interest organizations, and on the streets demanded enforcement, and plaintiffs filed lawsuits, that the sex discrimination prohibition began to become a reality. Okay, so I now want to shift gears a little bit and talk about how in the decades since Title VII's passage, advocates on the ground, in government, in academia, and advocacy organizations have really profoundly influenced the development of the law through their expansive interpretations of Title VII, sometimes really creatively inventing new claims. And I think sexual harassment law is a really great example of this. So drawing on a concept that was born of feminist activism and the courage of early plaintiffs, who notably were mostly African American women, and also on the creative legal advocacy of lawyers such as Catherine McKinnon and government officials such as EEOC Chair under the Carter administration, Eleanor Holmes Norton, federal courts and administrative agencies gradually began to recognize sexual harassment as actionable sex discrimination under Title VII. And this is a common theme in the history of anti-discrimination law, where advocacy groups have pushed for legal protections and then remained engaged in their interpretation and enforcement. And a few of the most famous examples of this involve a common pattern, which I've tried to illustrate on the slide in kind of a crude equation sort of format. So the pattern is this. The U.S. Supreme Court will issue a decision that interprets an anti-discrimination statute narrowly in a way that is not satisfying to advocates of anti-discrimination law. Those advocates mobilize, lobby Congress, Congress amends the legislation to make it more protective or to restore protections that have been stripped away by the courts. So an early example of this is when the U.S. Supreme Court in 1976 interpreted Title VII narrowly to exclude discrimination based on pregnancy. So the court reasoned pregnancy discrimination was not sex discrimination, but rather discrimination between pregnant and non-pregnant persons. Well, women's advocates were not satisfied with this definition of sex discrimination, and they mobilized immediately, the day of the decision, around the campaign to end discrimination against pregnant workers. And less than 2 years later, Congress passed the Pregnancy Discrimination Act of 1978. Another example is from the 1980s, when the Supreme Court again issued a series of decisions narrowing the circumstances in which various forms of discrimination could be remedied. In addition to very important advocacy by many organizations, Anita Hill's testimony at Clarence Thomas's confirmation hearings helped to create a political climate that enabled the passage of the Civil Rights Act of 1991, which was a very significant reform to Title VII. Most recently, the court told Lilly Ledbetter that she could not recover for decades of pay discrimination that she became aware of through an anonymous note because she hadn't known about it in time to file a claim. And one of President Obama's first acts in office was to sign the Lilly Ledbetter Fair Pay Act of 2009. This has become such a common pattern that Justice Ruth Bader Ginsburg, who of course herself was once a prominent feminist litigator, has taken to regularly writing dissents exhorting Congress to rectify the court's narrow interpretation of anti-discrimination laws. So one recent example of this is a racial harassment case in which the majority of the court interpreted the definition of supervisor very narrowly to shield employers from vicarious liability. And of course, this exchange between the various branches of government is not limited to race and sex discrimination. And I'll just mention quickly an example that deserves a lot more elaboration, and that's disability rights activism. Decades of such activism eventually produced the Americans with Disabilities Act, signed into law by the first President Bush in 1990. And then in a now familiar pattern, conservative court decisions on disability discrimination led to advocacy for a more expansive definition of disability incorporated into the recent ADA Amendments Act in 2008. Advocates have also continued to work through administrative channels, as Professor Lee just discussed, as well as litigation and legislative lobbying to expand the interpretation of existing laws. So I'll just give a couple of examples. After many years of advocacy by Professor Joan Williams and others, in 2007, the EEOC issued guidance expanding the interpretation of Title VII, arguably, to prohibit discrimination against workers with family caregiving responsibilities. And family responsibilities discrimination claims have been successfully brought by both women and men. Another example, which Professor Wolff will discuss in much greater detail, in 2012, the EEOC, again, after years of advocacy by interested groups, ruled that discrimination based on transgender identity should be sex discrimination that's prohibited by Title VII. Now, I don't want to paint too rosy a picture of advocates' influence on anti-discrimination law. For every triumph that I've listed, there are plenty of setbacks, and some of them are quite significant. For example, occupational segregation of women and men, mediated by racial segregation as well, persists. And feminist efforts to win equal pay for jobs of comparable worth fizzled in the 1980s. Title VII and the Equal Pay Act are notoriously ineffectual at remedying this pay discrimination, and fair pay legislation remedying it continues to be difficult to pass. Many of you are probably familiar with the recent large-scale class action lawsuit against Walmart, in which the Supreme Court, at least arguably, significantly cut back on employees' ability to band together in nationwide class action litigation. And of course, the U.S. continues to lag far behind other developed and developing countries when it comes to parental leave. Okay, so I want to talk now a little bit about where we are today in terms of the most promising avenues for sex equality advocacy under Title VII, and then try to provide a tentative overall assessment. So I think two of the most promising avenues for anti-discrimination advocacy today are related to sex discrimination. And the first is paid family and medical leave and pregnancy accommodation. Now, only 4 states and the District of Columbia require any paid family and medical leave, but that's several more states than did so a few years ago, so this is an area of significant potential. A dozen states and several localities, including New York City and Philadelphia, have recently enacted laws requiring at least some accommodations for pregnant workers on the job, including light work duty and temporary transfer to less strenuous positions. Women's organizations have argued that the Pregnancy Discrimination Act should be read in conjunction with the recent ADA amendments that I mentioned to require accommodations for pregnant workers on the job, and last year the EEOC essentially agreed with them, issuing guidance supportive of pregnancy discrimination plaintiffs. And as you may know, Peggy Young's case against UPS for failing to provide her with the kind of light duty assignment routinely granted to many employees with other temporarily disabling conditions is now before the Supreme Court. The second promising avenue, which I'm only going to briefly touch on because Professor Wolff is the expert on this and will be talking much more extensively about it, is discrimination based on sexual orientation and gender identity, which to a large degree has been attacked through the sex discrimination, thus far, through the sex discrimination provision of Title VII. A sexual orientation amendment to the Civil Rights Act was first introduced back in the early 1970s by Congresswoman Bella Abzug and Ed Koch. But strong public support for its contemporary descendant, the Employment Non-Discrimination Act, ENDA, has not yet translated into passage. But I did want to note that one recent survey found that more than 80% of respondents in the state of Massachusetts favored banning sexual orientation discrimination in employment. And perhaps more notably, more than 60% of Mississippians agreed. So I think it's possible to see the sex equality glass as either half empty or half full. So I'm going to give you both sides. On the one hand, advocates have successfully expanded the definition of sex discrimination to include sexual harassment, pregnancy discrimination, family responsibilities discrimination, and gender identity discrimination with sexual orientation on the horizon, potentially. Scholars and advocates have developed sophisticated theories of unconscious and structural bias, intersectionality, and other really important theories of anti-discrimination. On the other hand, when it comes to collective action and claims based on group-wide or systemic discrimination as opposed to individual cases of discrimination, advocates for plaintiffs have arguably fared less well recently. Two of the primary routes for attacking systemic discrimination, class actions, as I mentioned in the Walmart case, and disparate impact claims, which I haven't talked about in detail, have been endangered by recent Supreme Court rulings. And despite the central role of discrimination against women of color and the central role of women of color as activists in enforcing and expanding employment discrimination law, plaintiffs, women of color and others who allege multiple forms of interactive or intersectional discrimination fare even worse than already loss-prone discrimination plaintiffs generally. And as scholar Richard Thompson Ford has noted, employment discrimination law increasingly seems to be focused on identifying individual bad actors, those purportedly few individuals with invidious discriminatory intent, and with providing remedies for individual victims rather than tackling broader structural inequalities among groups. On the one hand, Title VII has arguably led employers to internalize legal norms against discrimination on the theory that there's nothing like looming liability to focus the mind. And significantly, by tying together the fates of various constituencies, Title VII has helped to produce strong and lasting coalitions between civil rights and feminists and other anti-discrimination advocates. On the other hand, the larger picture seems in many ways grim, with increasing income and wealth inequality taking a particular toll on already disadvantaged groups, especially men and women of color. We see a resurgence of structural barriers to equality within and beyond the workplace, such as resegregated and under-resourced education. And employment discrimination plaintiff success rates are notoriously low, despite the myth of windfalls created by the occasional large jury verdict. Now, it could be that low plaintiff success rates are caused by high rates of settlement or by non-meritorious claims, or it could be that they reflect real procedural and substantive barriers and real limitations of the law as a tool. But I think, on balance, I'm inclined to see the glass as half full, particularly in light of the history that we've talked about today. In any event, I think it's very clear from all that we've already discussed that there's a real need to look beyond the courts and beyond traditional measures of legal success in assessing not only the past, but also the present and future potential of the Civil Rights Act.
Just give people a chance to shuffle out if they need to, which is fine. We've got the room until 6 o'clock, and I want to leave at least a little bit of time for some Q&A with the audience. So I'm going to make some brief remarks about two related issues that have to do with the current areas of contestation around anti-discrimination laws in general and the Civil Rights Act in particular, which are religious objections to compliance with anti-discrimination laws and the protection of people from discrimination in the workplace based on sexual orientation and gender identity. A couple of words about each. First of all, the issue of religious exemptions. When the Civil Rights Act was initially drafted, it contained within it, as one of the compromises in the bill, a relatively narrow religious exemption. And it was an exemption that applies to religiously affiliated organizations only, not to secular private employers. The definition in the statute reads that if you're an employer whose purpose and character is primarily religious, then you qualify for this exemption. And it gives religious employers an important but limited privilege or prerogative that nobody else has, which is that they have the prerogative of maintaining a workplace of co-religionists. That is to say, they can make decisions, hiring and firing decisions, based upon the religion of applicants or the religion of employees. And originally this exemption was defined under the Civil Rights Act to include only positions that have a religious character. It was actually expanded to be just a general prerogative to make hiring and firing decisions based on religion, once again by these religiously affiliated organizations, in 1972 in conjunction with the passage of the Education Amendments, which expanded coverage of the Civil Rights Act with respect to educational institutions. And so for about 40 years now, a little over 40 years, religious organizations have had the prerogative to hire and fire based upon religion. What they haven't been able to do, and what they're still not able to do, is hire or fire based upon other protected categories in the Civil Rights Act. So if you're a religious organization, you can choose to only hire members of your own religion. You can't make hiring decisions based upon race, based upon gender. The one other religious exemption that for a time was taken to be an implied component of the statute, and in an important Supreme Court decision a couple of years ago was recognized as a constitutional prerogative, has to do with ministers, a so-called ministerial exception to anti-discrimination laws. So despite the fact that the religious exemption said you can only make decisions based upon religion, not based upon other protected categories, everybody always understood that the Catholic Church could choose to hire men as priests and not women as priests because the Catholic Church has a sex discriminatory policy with respect to who is allowed to be priests, right? And it was understood that the Civil Rights Act didn't touch that because there was understood to be an implied exception. That's now been recognized as an express constitutional prerogative. But what it doesn't authorize is, for example, a religious organization to make decisions within the workplace based upon sex and race stereotypes. And so one of the most frequently litigated types of claim of this character, and there's a bunch of reported decisions on this, have to do with unmarried women who become pregnant and have jobs with employers that are qualifying religious employers, and that take punitive action against these women because they've gotten pregnant. Now, because of the enactment of the Pregnancy Discrimination Act of 1978, this constitutes sex discrimination within the workplace. And the lawsuits usually, when they arise, usually center on the question of whether employers are targeting pregnant persons, or not pregnant persons, but specifically people who have sex out of wedlock. And it's simply the unfortunate lot of women that the physical evidence of the fact that they have probably, not inevitably, by the way, but probably had sex out of wedlock is evident, and therefore they're the only ones who unluckily get targeted, right? And does that qualify as targeting someone for a reason that is both not sex discrimination and that has to do with a tenet of the religious beliefs of the employer? Actively contested issue, and the short of it is that courts have generally approached these claims rather skeptically, and both defined narrowly the scope of the religious exemption and also found that if you're targeting women for having premarital sex, but you're not targeting men for having premarital sex, for example, you're not asking men whether they're having premarital sex as part of your policing of the activities of your employees, that's sex discrimination and the exemption doesn't apply. So that's the exemption that exists under the Civil Rights Act itself. So the modern discussion, that is to say contemporary discussion, around the issue of religious exemptions to anti-discrimination laws has focused primarily around protection of gay, lesbian, bisexual, and transgender people in the workplace and also in places of public accommodation. And many of you are probably familiar with recent events having to do with the failed attempt to enact new legislation in Arizona. Similar attempts have been made in Mississippi and Colorado, seeking to expand state law exemptions to state anti-discrimination laws, both in the workplace and in places of public accommodation, to either carve protections for LGBT people out expressly, or if not that, then to create sort of a general all-purpose license on the part of religious organizations or religious adherents, sometimes just private for-profit businesses, to decline to comply with otherwise applicable laws, including anti-discrimination laws, because they have religious objections to doing so. There's a very active debate right now about the question of whether such special religious exemptions are appropriate, and if so, whether applying them to anti-discrimination laws is an attractive or permissible public policy. At the federal level, LGBT workers don't enjoy any explicit statutory protection from discrimination in the workplace. Now, that's a very important qualifier, explicit statutory protection. In recent years, the picture for protections within the workplace for LGBT workers has gotten a lot better as a result of a couple of developments. One is one that Professor Mayeri has already talked a bit about, the recognition that at least with respect to transgender persons, discrimination on the basis of transgender identity or status, including discrimination because a person undertakes a transition of the way that they present their gender to in public spaces, constitutes discrimination based upon sex, constitutes discrimination because of perceptions about gender roles, perceptions about gender identity, which have previously been recognized in cases involving men and women who have an expected gender presentation but depart from gender norms in various ways, right? Women who don't want to wear makeup in the workplace, for example. Women who are, actually, there's a bad precedent on the issue of makeup, which is a ridiculous case, which we won't talk about, but women who are, quote unquote, too aggressive and act too much like men and therefore don't get promoted within the workplace, right? These are principles that have long been established for men and women who have what is taken as the socially normative gender presentation within the workplace. Those same principles have started getting recognized on behalf of transgender workers as well. Second, very important development was executive action taken by President Obama this past summer in promulgating an executive order that added sexual orientation and gender identity to an existing federal order, executive order, relating to discrimination by private federal contractors, that is to say, private companies that do business under federal contracts with the federal government. Using existing statutory authority, President Obama promulgated an order that had long been urged upon him by LGBT advocates to require that in addition to federal contractors having within their own workplace policies that prohibit discrimination based on race, sex, religion, and other categories that are covered by Title VII, that private federal contractors also have to have internal policies that prohibit discrimination based on sexual orientation and gender identity. And I think that the estimates are that something on the order of 30% of the private workforce is affected by and covered by that order. It doesn't provide an ability for people to bring individual lawsuits when they're subject to discrimination, but it provides an enforcement mechanism that there's good reason to believe is going to be quite powerful when it comes to federal contractors who want to, private businesses who want to do business with the federal government. The other major issue that is on the horizon right now at the federal level is the possibility of enacting explicit statutory protections for the workplace for LGBT people in the form of the statute called the Employment Non-Discrimination Act. In many ways, this is a terribly crafted statute. It's gotten better over the years, but it has been laden with a whole bunch of compromises and qualifications to the types of protections that would be made available to LGBT workers. And one of the big issues that's been the subject of some debate recently has been the inclusion of a religious exemption in that statute. The religious exemption of the Civil Rights Act, as I mentioned, applies to religious organizations, but only gives them the prerogative to maintain a workplace of co-religionists. It doesn't authorize discrimination based on sex or race or national origin or color, right? The proposed religious exemption in ENDA for many years was one which would have said qualifying religious organizations can just flat out discriminate based on sexual orientation or gender identity. They get an exemption from the entire sweep of this statute. That was a compromise that advocates lived with unhappily for some time, and in recent debates around the reintroduction of this statute, there's been a movement, which I've been a part of, I will disclose, to take that excessive exemption out of the statute and to have the same exemption that applies to the Civil Rights Act also apply to the proposed Employment Non-Discrimination Act as well. There's a lot more to talk about in the claimed incompatibilities sometimes between religious autonomy and the enforcement of anti-discrimination laws. If there's interest, I'd love to do it during Q&A, but let me just wrap up now and we can turn the rest of the time over to questions. Thank you.
Well, thank you. I want to thank all four of you. I've taught this statute in my classes for many years and thought I knew it, but I realized how much I didn't know, and I learned from each one of you, as we all did. So thank you. We do want to give you a chance to have some quick questions if there's interest, and I think we have some volunteers with some microphones here. Thank you, George. So if you have a question, raise your hand and they'll find you. First one right here.
Hi, thanks for holding this event today. My name is Blair Bowie, I'm a 1L. My question is mostly for Professor Wolff. I want to hear a little bit more about whether you think, whether you think it's possible that, as a couple of federal courts have done, the Price-Waterhouse gender stereotyping theory can be applied to sexual orientation.
Sure. So the path to recognizing that discrimination against transgender people, gender identity discrimination, is sex discrimination, has always been very clear. And it was really the resistance to it, recognizing, so for example, one of the arguments that was often raised was, well, we're not discriminating against a transgender person because of their sex or their gender, it's because they've changed their sex or their gender, and we find that to be problematic. Well, of course, if you discriminate against somebody because they changed their religion, that's anti-religious discrimination, right? And, all of the arguments about why anti-trans discrimination somehow didn't constitute sex discrimination failed to hold up under scrutiny. It just took a long time for people to recognize that fact. Sexual orientation discrimination, the way that you make the argument is relatively straightforward, right? It's a combination of several, the analysis has several pieces. Number one, what we normally mean when we are identifying gay, lesbian, or bisexual identity has to do with the sex or gender of your preferred or exclusively available romantic and sexual and life partner, right? And so if you discriminate against somebody because they say they're gay, lesbian, or bisexual, you're discriminating because you're making reference to the issue of gender, that is to say the gender of their partner and what you view as the appropriate gender of their partner. Number two, in real life, sexual orientation discrimination is almost always intimately bound up with a set of ideas that people have about sex roles and about gender, about the way that a man should act, about the way that a woman should act. And it's a very, it's a theoretical exercise to suggest that these things can be disaggregated, right? And so the argument, in one sense, is relatively clear and straightforward analytically. It's also the case that there are a bunch of people, many of whom are down with the idea that sexual orientation discrimination is impermissible and should be prohibited from the workplace, who just have a visceral sense that there is some difference between sex discrimination and sexual orientation discrimination. That they get the argument, but that the sort of intuitive, satisfying quality of the argument is not the same when it comes to anti-LGBT discrimination as it is when it comes to anti-transgender discrimination. And that, I think, is simply a question of getting people used to thinking about sexual orientation as being an aspect and a dimension of gender and of sex. And there's perhaps a diversity of views about that, but I think that the acculturation of our legal community and also to some extent of our popular culture is coming along. So I think the prospects are real, and I can tell you the EEOC is very interested in this issue. And they have a number of cases on their docket that will give them an opportunity to speak to the issue. They've already spoken to components of the issue when talking about the difficulty of disaggregating gender stereotyping from sexual orientation discrimination. So it is very much an issue that's on the EEOC's docket.
Okay, I see a few hands back there.
This is another question for Professor Wolff. I'm wondering how the courts would deal with certain religious groups or denominations that don't hire women into positions of power, for example, as members of the clergy or as elders in a church, and what the courts would do with that.
Yeah. So insofar as what you're talking about are positions that have ministerial or religious teaching or doctrinal dimensions to them, the answer is that churches and religious organizations have an absolute prerogative to discriminate however they want to in making those hiring decisions. And the reason for that is the protections of the Free Exercise Clause in the First Amendment. And that had been widely understood to be the case for quite some time. The Supreme Court 3 years ago in the Hosanna Tabor case held that to be the case. And so insofar as what you're talking about is priests, ministers, teachers who have a ministerial or doctrinal component, including music directors sometimes, discrimination laws don't touch that at all. Insofar as what you're talking about is positions that are high-level positions but that are non-religious, non-doctrinal in nature, anti-discrimination law should apply with full force. At least the federal anti-discrimination law should.
I see two questions up there. One of you is holding the mic. Is there anybody over here? And then So I think we have time for about 3 more questions if you're brief. Thank you.
My question is for Professor Mayeri. You spoke about the continuing legal difficulties that people who find themselves at an intersection of inequality face. I was wondering if you could speak more about that and perhaps give an example.
Sure, absolutely. Thanks for the question. So for many years now, arguably since Title VII was enacted, but certainly in the last 25 years or so, there have been extremely sophisticated and important scholarly work about theorizing intersectionality and theorizing the ways in which people who have more than one, are members of more than one category that's subject to discrimination and subordination are disadvantaged in the workplace and in other areas of the law. Courts have not picked up on this much. There's certainly been progress in the way courts have looked at intersectional claims in theory. So courts have, in the past 20 years or so, begun to recognize the possibility of bringing, for example, a combined race and sex discrimination claim. So a woman of color who brings a claim saying, I was discriminated against on the basis of my race and my sex. Some early courts said, you just can't bring that kind of a claim. You have to show either that you were discriminated against on the basis of race or sex and make that claim independently. So what that meant in practice was you would have to show not only that for example, African American women were hired for the position that you were seeking, but that no African American men or white women were hired. So that evidence that an employer had hired any kind of a woman or any kind of an African American was enough to defeat a claim. That's no longer true, although there are many courts who have not even really directly addressed that issue. Courts who have addressed the issue in the past 20 years have come to the opposite conclusion. But nevertheless, recently, empirical studies that have been conducted by a number of scholars, including Linda Krieger and Minna Kotkin, have shown that measuring the success rates of intersectional plaintiffs who are alleging multiple forms of discrimination, either sort of multiple forms that are happening kind of in conjunction with one another, or even multiple forms of discrimination kind of in an additive sort of a way, fare significantly worse than employment discrimination plaintiffs generally. So there's, I would say, a really wide gap in the theoretical sophistication of arguments about intersectionality on the one hand, and on the other hand, the way courts have tended to treat those kinds of claims in practice.
Okay, did I see your hand? Yes. Let's get the microphone there. And any other questions after this? Okay, and then we've got, so two more, so we'll go here and then go to the other side, and then...
This one is to the whole panel. We've heard examples today in the presentations, which are all wonderful, by the way. We've heard examples in the presentations of state and local laws actually providing additional protections additional to federal law, but also examples of state and local law being used to frustrate federal objectives. Any thoughts on the future role that state and local law will play in this area?
Professor Lee, do you want to?
I feel like you might be best suited to.
Sure. Well, a couple of things. One, Professor Mayeri made some reference to this. It's worth reiterating. The Supreme Court of today, the Supreme Court of the United States of today, is the most conservative Supreme Court that most people in this auditorium have seen in their lifetimes. The regressive direction of the interpretation of federal anti-discrimination protections and the consistency with which that direction has been regressive has been really quite remarkable. And so state and local laws have been playing a very important role in providing protections that are both qualitatively different and greater in some respects, and also whose enforcement is